What happens when your mom has a stroke, can't talk, physically disabled, can't write, and doesn't have any estate planning? What do you do? That was a situation that I encountered today when I went to my new client's house to meet her and this 88-year-old woman who suffered a stroke fairly recently, lost the ability to use her writing hand, and lost the ability to verbally communicate. What do you do in that situation? Is a person stuck? Are they able to do any sort of estate planning? Do we have to go to a conservatorship right away? What's the situation and why is this important? Well, the son, who is 60 himself, mom was living with him, and he is running into some challenges in trying to help mom pay some of her medical bills and her bills in general, manage her life, because before she would simply get on the phone and say, yes, you can talk to my son. Sadly, now she can't do that after her stroke. And there's questions about whether she's really understanding what's going on. But of course, she can't communicate anything over the phone. And it's very difficult to transport her, given her physical disabilities, to in person to a bank. And so the son reached out and said, what can we do? I've realized my mom doesn't even have a power of attorney. And this is becoming a real problem and a challenge. Do I need a conservatorship? And so I didn't have to, I really wanted to, and enjoyed going over to this new client's house and meeting her to be able to engage in an assessment of whether or not what was needed. But it really brought up a question that my new clients had, and the son had, about, well, how can we even sign documents if my mom can't write? My mom can't communicate. Is that endgame? And the answer is it's not. And outside of the specific facts of this particular client situation, and everyone's facts and circumstances will be different. So I can't say in every situation there would not be a conservatorship proceeding. Conservatorship, it might be, but let's just look at the fact in and of itself that a person cannot physically sign their name does not mean that they cannot engage in estate planning. The issue isn't one of physical signature. The issue is one of cognition and the capacity to understand what you are doing. And the law is a little bit more nuanced, and depending on what type of legal document you're signing, there might be some additional analysis. Well, do you understand that you have the requisite capacity at a testamentary level or at a contract level? So if we are looking at filling out a trust or a will, that's a different level of understanding under the law than signing a power of attorney or a healthcare directive or perhaps some other contractual document like a lease. So there's different analysis and different levels. This is not a video that's going to go into the nuance and bore you about what the law says, the statutes, the case law about that. Just know that the court's going to look at whether or not a person has the ability to understand, and that is going to be different depending on the legal document. And that threshold of does the person understand is also different from a medical perspective, never mind a layperson's perspective. Oh, I think mom understands me, I can tell. Or yes, mom definitely understands. That might be different. A doctor might say something different and a court might say something different. But the fact of the matter, it doesn't boil down to mom can't sign her name, so therefore she can't have a legal document. The law allows, number one, you to make a mark. It doesn't have to be a physical signature. So your signature could look different than it did because physically your hand has a tremor, or you're using your left hand instead of your right hand. But you don't have to, they're not going to compare and match your signatures. And that's not the legal standard. You can make a mark. And as long as you have two witnesses that are uninterested, meaning that they bear no relation to you or your planning, so that they're uninterested parties, neutrals. That could be your lawyer, that could be the notary, that could be somebody from the lawyer's office, it could be your neighbor. As long as there's two witnesses that witness you make that mark, and those people know you, or they can be proven to them who you are with a government ID, then that's enough under the law. Furthermore, and this varies from state to state, but furthermore, even if you can't make the mark, let's say because of the stroke, you've lost all the ability to use your limbs, or you were in an accident, you're paraplegic, and now we have a brain injury, we have a physical injury situation, we don't have a cognition issue, no brain injury, but you can't use your hands to sign. Or obviously, as long as you can make a mark, there's different ways you can do it. But if you don't have meaningful control over parts of your body that would allow you to hold a pen to make a mark, there are other things and other processes that the California law allows. So we can use other methods like tracking eyes, movement of head. Again, all that needs to be done with witnesses that are uninterested, and it could still work out. Best practices are to maybe document this with a video, record the situation. And again, having neutral parties there to be witnesses, not just because it's a requirement under the law, but just in general, so that there's no misunderstandings. All good practices and things to think about. Last piece is consult a lawyer, consult an attorney that is experienced in estate planning and elder law, particularly. Helpful if that attorney also has experience in litigation to know what the arguments might be, successful and unsuccessful ones in court that happen later in situations like this, where there could be challenges to the validity of the signature on the grounds that the approving capacity in the person, were they able to understand what you're saying? If they're nonverbal, they cannot communicate that they do. How else can they communicate non-verbally that would be upheld to demonstrate that they had capacity? But remember, everybody has presumed to have capacity under the law, and unless that presumption is rebutted by other evidence. So if there's no evidence, that someone doesn't have capacity, you're not starting from a premise of, I have to prove I have capacity. No, you only have to prove you have capacity if somebody else has already proven that you don't, or there's a strong chance that you don't. It's more likely than not that you don't. So talk to an attorney. You're not expecting you to remember or do this on your own. This is not legal advice for your situation. So talk to an attorney that's experienced this area to help you walk through the circumstances you're dealing with. I would just hate for you to say, I'm just assumed that we couldn't do documents because mom or dad or whoever loved one could not actually physically sign their name on a document. That's not the standard. So there might still be something that they can do. You need to make sure that you're pursuing that final answer. Look under all the rocks to get the solution. My name is Kevin Snyder. I'm an estate attorney, and we have lots of other great videos on this stuff. So if this is of interest to you, found great value, and please share with somebody, because you never know who you can help with this information. Check out our other videos, share them too. We just were trying to get the word out. And until the next time, keep being amazing.